Good morning, everyone. We're going to wait just a couple more seconds to let people arrive. Okay, we'll get started here. Good morning again. My name is Josh Stripmatter, and I would like to welcome you to Stripmatter Wealth Smart Money Webinar Series. Thank you for joining us today. Our presentation today is titled The Estate Planning You Need to Know. For those of you that don't know us, we are Stripmatter Wealth Management Group, a registered investment advisor located in downtown Fort Worth. We specialize in investment management, financial planning, estate planning, and real estate investing. We've been in business since 2007 and serve clients throughout the United States. A little bit of housekeeping before we get started. All of you have access to the chat feature. So if you have any questions, please don't hesitate to type those in. We'll be happy to answer those for you. Also, we'll be sending out a replay of today's webinar via email. So if you miss something, don't panic. You'll have the ability to watch this again. And you are welcome to forward these presentations and any of the presentations to your friends and family if you think it would be beneficial. Today's webinar is meant to be purely educational and not meant as tax or legal advice. Please talk to your licensed professionals before taking action on any of the information in this presentation. For more information, including key disclosures, please visit our website at stripmatterwealth.com. Let me introduce our speaker today. Our speaker is Karen Telschow Johnson and is an asset protection attorney who focuses on estate planning, advanced care planning, and elder law. She is licensed in Texas and has been for the last 20 years. She is a graduate of Texas A&M University and Texas A&M University School of Law. She's a proud mom to her two children, Morgan and Ethan, and has two dogs who get her out of bed for a walk every morning. So without further ado, let me hand it off to Karen. Karen, good morning. How are you?
All right. Good morning, Josh. Great to see you. Good to be here.
Good to see you.
So as I tell everyone, it is always good to be above the dirt.
That's absolutely true.
Yes. And so we all have our little aches and pains as we get older, but we always know that as long as we're above the dirt, we can move forward with our lives. And that's always a blessing.
You bet.
All right. So thank you for having me here today. We are talking about estate planning that you need to know. And because the fact of the matter is, usually when someone passes away, within a few days, I receive phone calls that say, well, what do I do now? Or what's next? Or how's the mortgage being paid next month? And, what happens with our accounts? Well, it's very important to understand one very clear thing in the United States and how we handle our estate planning. And we're going to go through that now so that we can help you through understanding what that process is. I want to make sure that. So we're going to be discussing what happens when you have a will, what happens when you don't have a will, and the potential of utilizing a trust and other asset transfers that can make your life easier. So in the United States, the most clear thing to take away from today's presentation is how will your assets pass when you die? Because in the United States, we live in an asset distribution system. And what does that mean? Well, there are quite a few countries that have an administrative system when you pass away. And what that means is that all of your assets will pass through this administrative body, and then they will be administered according to the terms of what you have set up in that administrative function. And so everything goes through a clearinghouse. That is not what happens in the United States. In the United States, every single asset passes according to its own laws. So that if your bank account has a beneficiary designation, that account is not going to pass according to the terms of your will. It's going to pass according to the contract that says that your beneficiary is this person and they're going to receive your funds. And if you haven't looked at your beneficiary designations in a while, that could be a former spouse. That could be that maybe in your 20s when you opened up the account, you put your mom and dad. And they're either deceased or you really at this point would want your assets to go to your spouse or to your children. And so it's very important to look at beneficiary designations for your accounts. And what I tell my clients is the easiest way to do that is to simply make a phone call to your financial institution and say, what happens when I die? And that will give you the answer that you need. If they say, oh, it'll pass according to your estate, or you'll just need to get letters, that means there is no beneficiary designation. Or if they say, oh, well, it's to, it's to your mom or it's to your dad and those people who predeceased you, you need to update those. I've even had accounts passed to former spouses. Just because you've divorced them, the contractual obligation for the financial institution isn't necessarily to honor that divorce decree, not for all financial accounts, certainly for some, but not for others. And so it's important to make sure that those accounts are updated. Also, real estate in the state of Texas can pass via beneficiary deeds now. And so that may make real estate transfers easier. But what is the gold standard for protecting what your legacy is to be? And that is utilizing the last will and testament. Having the last will and testament reflects your legacy. I appreciate people who want to try and save pennies. I'm a big fan of that too. And as an investor, I'm sure Josh makes sure your pennies grow as well as they can. But what needs to reflect your legacy is a will that is properly prepared by a professional. And so I do appreciate these form wills, but frankly, form wills have given me a lot more business in probate court than you can even imagine. Because sometimes a form will misses who a beneficiary is supposed to be, or it lists somebody who is no longer supposed to be a beneficiary, or it simply has wrong language. And so I cannot probate it because the language doesn't meet the will execution requirements. And so it provides for an expanded probate or even a partial intestacy because it doesn't completely distribute the estate as it should be. And so form wills are really kind of upping our probate work. And that's not the best and most efficient way for an estate to pass. And that leads to a lot of problems. And so that when we go into court and we're having to probate your will, we're having to probate it because we need an asset that needs to transfer with a court order. So you walked into Bank of America or Chase and they say, oh, just get letters and you'll be fine. What they're telling you is that they need letters testamentary, in other words, letters to appoint somebody to have legal authority over your estate as the testator, as you stated in this document, so that they can act according to the terms of your estate. So they'll say, oh, we'll make a check out to the estate. Well, only somebody who has legal authority can then open up an estate account. And so it's not as simple as go get letters. It's making sure that you have letters pursuant to a will that reflects what you want and that will is updated. And so when you have a plan, you remain in charge of stating that these are the people I trust to administer my estate, right? So this is my executor. That's your actor in your will, is your administrator, is your executor. When you, if somebody is listed as an executor and they're not able to serve and we don't have an alternate, they're appointed as an administrator. And so sometimes the words executor and administrator are used hand in hand. They have the same role. In your will, you can also have a contingent trust, and that means contingent upon its necessity, so that we can plan for our children in our will so that our children don't inherit, say, at the age of 18, so that if you want them to take in staggered distributions at 25 or 30 or whatever ages you say, you can have a contingent trust in your will that can also help protect minors. And so, and when you have a plan in your will, you have the beneficiaries listed that you want to receive an inheritance, and not necessarily any other bad actors. And so that remains in control. But what happens when you have no will? When you have no will, but then we still have to administer an estate because we're dealing with real estate that that needs to be transferred, then we have to follow the laws of intestacy of the state of Texas. And how do we do that? We have to file with the court a determination of heirship proceeding. And that proceeding is where we file an application saying, these are who the heirs are under the law. If you're married and it's your first marriage, community property is just going to go to a spouse. If you have children, all of that first marriage, it's all going to go to the spouse. If you have children from another relationship, they are going to take a larger intestate share. And so your spouse is not going to end up with that community property. Your children from your other relationship will. These types of fallouts are unfortunately becoming more common. I had a client 2 weeks ago who called me. They had been married for 10 years. He had children from a prior marriage. He did not update his will. They could not find certain pages of his will, which made the will something that we couldn't even probate because we were missing signatory pages. And so his children from his other marriage are the ones to take 100% of his community share. That was not the result we're sure that should have been intended, because they own two properties together. But that's the result. That's the result of that estate and passing without a will, because the heirs are actually the former children and not his current spouse. And so we also then have extensive court proceedings, because not everybody is going to agree on how the assets should be distributed. So we end up with family settlement agreements. And I just tell people over and over, if you just update your will, we can avoid intestate distributions. Importantly, what happened a few years ago is I had a 92-year-old woman say hello to a 72-year-old illegitimate son that she did not know about, and ended up having to sell her house or their home in order to make him whole. And so these are consequences that can be avoided if there's just a document that says, when I die, my estate goes to these people. And so that could be very helpful. So avoiding those types of consequences is something that I encourage all to do. Also, in these days of 23andMe and these days of legacy.com and ancestry.com, we find people, and the court has to appoint an attorney on behalf of the unknown heirs to do a more thorough investigation than just one that the applicant has filed, so that there is verification and validation of the proper heirs of the estate. And so let's not find anyone and prepare it properly. And so we can use a will to certainly transfer our assets through a probate process. And Texas really has an independent probate proceeding, meaning we go to court one time, letters testamentary are issued to the executor, and then everything else is done outside of court. And it takes about 4 months, because we have a 120-day creditor claim process where creditors have the right to file claims. And then we pay bills, and then we make distributions to beneficiaries, all outside of the court system. And so, but some people want to avoid the court system altogether. And there's a lot of different reasons for that. So, and one of the ways to do that, and the most common way to do it, and the most efficient way to do it, is to have a trust. When I'm talking about trust for the purposes of our conversation, I'm talking about a revocable trust. There are irrevocable trusts. There are spousal lifetime access trusts. There are charitable remainder trusts. There's about 10 to 20 different more types of trusts that are used in estate planning. We are not talking about all of those today. Literally, I could speak for an hour just on all of the different types of trust. The most commonly used trust is a revocable trust, and that's what we're going to be referencing. In a revocable trust, it's like a revocable trust is like hiring a babysitter. All right, so let me explain that scenario to you. And so I'm going to give you $25. And as the $25 is going to be the trust corpus. All right, and you are going to use that $25, and I'm going to hand it to you as the trustee. So the trustee is going to have equitable title to the trust asset. And I'm going to say, I want you to spend it on behalf of the beneficiaries, my kids, Morgan and Ethan. I want you to go take them for ice cream. So then you're going to go take them for ice cream, and you go to McDonald's, and they're going to get the fries and the nuggets and whatever. And then they're going to come back. You're going to come back, and you're going to hand me the $5 change. When there is no more trust asset, there's no more trust. It terminates of its own accord. And so, but I asked you to take them for ice cream. You took them for McDonald's. They got that chemicals in a cone. There's no ice cream in McDonald's ice cream. There's just not. And there's chemicals in a cone. So technically you've breached your fiduciary duty. So either the beneficiaries or someone on behalf of the beneficiaries can then sue on their behalf. And that's how trust provisions are enforced. All right. So that's why it's like hiring a babysitter, because a trust is only as good as the trust assets. Its sole purpose is to spend on behalf of the beneficiaries. And so, and then when you set up a trust and you're the initial trustee and the grantor of your existence as a trustee as a part of your trust, you're the only beneficiary to begin with, right? So it's typically you or you and your spouse are your initial trustees, your initial beneficiaries, and only after the second of you dies, potentially, or after you die, if it's a single trust, then the provisions become irrevocable. So then nobody can then go ahead and change in your legacy. The other issue is if you're a co-trustee, say with a spouse, and that spouse becomes incapacitated, you can handle all trust assets without ever having to go to court or ever being prey to the pitfalls of whether or not a power of attorney is going to work for that transference of that trust asset, or whether or not you need to do a refi. If it's trust property, alternate co-trustees can sign documents on behalf of the other without two people having to sign. I'm a part of the board of directors of the Alzheimer's Association. And when we have initial diagnoses of dementia or Alzheimer's, specifically what we do is make sure that we set up the revocable trust as co-trustees so that down the road, when only one of them really has capacity to sign, they can still do that without having to go to court and get potentially a guardianship proceeding to act. The other benefit about a trust is that if you have out-of-state property and you transfer it into the trust, it's no longer in that state for the purposes of descent and distribution. The trustee has the right to transfer that property without having to have a probate proceeding in that other state. And so we can eliminate multi-jurisdictional probates if we simply just have it titled into the trust. So I have clients that have one trust and they have property titled in it from Florida, property titled in it from Colorado, from Hawaii. And so even importantly, even when you're dealing with townhomes, condos, timeshares, all of those are real property interests that if you hold as an individual, you can also hold as a trustee of your trust. And so you can title the trust as a beneficiary for any of your accounts, which can also make that transfer seamless. And then you can also put in special needs trust provisions if we're having to deal with any member of your family who would potentially end up on public benefits because we're dealing with mental health issues, addiction issues, or any of these other problems. There are things that we can do within a trust that can make it very helpful for families, and then it all remains private. And so in our will, when we have a trust, in the will is our backup plan, because you always want that as a backup plan. The will is simply a pour over will that says that if anything falls and needs a court order from the will, it's just going to pour over into the trust. And then the trust has all those details maybe in dealing with your family that you don't want anybody else to see, right? So like we've had clients that, you know, she has an adult son who's an alcoholic and she just wants to make sure that he always has a place to live. The properties are in the trust, the expenses are in the trust, everything goes in and out of the trust, but then he can't touch it or do anything with it. And she's assured that her son will always have a place to live. And so also that doesn't need to be in a will. A will is filed as a part of the public record, right? But those family matters that are private to a lot of families, you can put special provisions in a trust that can then also remain private with your family. And that's the benefit of a trust as well. It's always private. If it ever has to go to court and be disputed, we just put in that one disputed provision, the judge takes it in camera and then decides whether or not it gets filed. And so it's a very private process as well. So with real estate transfers, out of state transfers, you can easily put into a trust. Also, states have beneficiary deeds. Again, a transfer on death deed that says when I die, my property goes to this person. Not all states have beneficiary deeds. They're very specific as to per state. Texas also has a ladybird deed. Texas and about 7 other states has an enhanced life estate deed that says when I die, it goes to this person. Added benefit for beneficiary deeds and ladybird deeds is they help protect against Medicaid estate recovery in the event you've ever had to use that for long-term care. And then mineral interest. You can put mineral interest in a trust. You can also use transfer on death deeds with mineral interest, which can be helpful to a lot of families as well, that I've been doing a lot more of those. So something else to consider also for transfers are your digital assets. Anytime you get online, you do banking, you do Facebook, there's a lot of your accounts that are affiliated with Google. All of these different entities now are starting to create legacy appointments. And so you can go onto those pages and type in legacy, and then you can list somebody as a legacy appointment. I've recently had a case where we had to deal with Apple and unlocking a phone. We can use a court order after somebody has died to unlock a phone, but without that 4 or 6 digit code, they have to erase the data prior to being able to open it. And so all of those things are important to consider when talking about your estate plan and how to handle specifically digital assets. So, best estate planning lesson ever learned. You will never be completely ready for the next step. You will never be completely ready for, this is my estate, you know, I'm going to set this all up now. Move forward anyway. Your will, your trust encompasses everything you own and everything you owe as of the date of your death, right? So whatever your real property is, and real property is everything related to dirt, and whatever your personal property is, and personal property is everything that's not dirt, are covered by your will and by your trust, because it says whatever those things are, when I pass, this is how they're going to transfer. So you don't necessarily have to get bogged down in the minutia and knowing what everything's going to be or who's going to get what. Most of my clients set up percentages for distributions, not knowing exactly what the total amount's going to be, but they want to reflect the percentages going to certain people, not saying this person gets $250,000, this person gets $1 million, this person gets $5. I encourage clients not to get bogged down in dollar amounts because you don't know what that's going to look like, but percentages certainly help. So move forward anyway. This is our team. And Brenda's been a paralegal longer than I've been a lawyer. She's wonderful. Nicole handles all our administrative work, and Rebecca handles client relations. And that's my dad. He works for me and he does special projects for us. And we just hired another attorney and another paralegal, and that's Monica and Martha, and they'll be added to all of our social media posts soon. But thank you very much for your time today. It's been, I always like dealing with Josh's clients because they're usually on top of things and are always willing to learn. And if I can be of help in the future, please reach out.
All right, Karen, thank you very much. Great presentation.
Thank you.
So we will take just a moment to take some questions. Let me bring up another slide here. And as we wait for that, if you have any questions, you're welcome to contact Karen directly, or you can also contact my office at 817-210-3444. Email us at clientservice@stripmatterwealth.com. You can go to stripmatterwealth.com to sign up for our weekly newsletters, which are, we have a market update, we have a monthly retirement update, and then we have an events newsletter that we send out once a month as well. Also join us on our radio show on Saturdays at 10 a.m. on 1190 a.m. on a show called Ask the Experts, where I answer your financial questions. So that said, I'm going to stop recording, but before I do that, say thank you to everybody. And then we'll take some questions. Give me 1 second here.